I'm back. Done with the doctor. And now just had a quick lunch. And we'll go back to reading where we left off before. So we are going over Kathleen's filing today to the Court of Appeals. It's how many pages? 150 pages. And we are currently on page 100 out of the 150. So, who am I? That everybody asks. My name is Jax West. I run Stephen Avery Project, MAM Gossip. Oh, I didn't put this automatically in the other groups. I forgot. I don't think I can do that now. Oh, well. No biggie. While I'm reading this, I will not be reading your comments and whatnot because I'll just be reading from this the brief. So, and then my laptop is stupid and sometimes periodically shuts down on me. So I have to try and remember to move my mouse on the page so it doesn't shut down. So here we go. Where we left off from earlier, from an hour ago. In State versus Thiel, the Wisconsin Supreme Court granted post-conviction relief after the trial defense attorney failed to conduct a significant investigation. There, the defendant set forth precisely what would have been revealed had the trial defense attorney conducted an investigation consistent with the defendant's constitutional right to counsel. In the instant case, Thiel also supports Mr. Avery's position that relief is warranted because his trial defense attorneys were ineffective in failing to properly review the discovery prior to Mr. Avery's trial to fully understand Brian's statements to law enforcement. In Thiel, the defendant's allegation that his trial attorney had not reviewed all of the discovery constituted an additional basis for the Supreme Court to grant relief. The same result is compelled here. Brian, and she's speaking of Brian Dassey, the oldest Dassey boy. Brian was available to testify at Mr. Avery's trial and could have impeached Bobby on this critical piece of information that led to Mr. Avery's conviction. If Mr. Buting and Mr. Strang had effectively cross-examined Bobby, they could have impeached him by calling Brian. The state's most important eyewitness would have been discredited, and the state's theory that Ms. Hallback never left the Avery property would have been refuted. Brian's testimony would have been a game changer. Applying the correct Strickland standard to the failure of trial defense counsel to impeach Bobby, it has been demonstrated to a reasonable probability that if Brian had been called as a witness to refute Bobby's statement that Ms. Hallback did not leave the Avery property, that would have been sufficient evidence to undermine the verdict. Clearly, the jury perceived that Bobby was the most important state witness in establishing Mr. Avery's guilt because the jury, during deliberations, requested to review Bobby's testimony. Wisconsin has long held that impeaching evidence may be enough to warrant a new trial. In Mr. Avery's audio-taped November 6, 2005 interview, he told the Marionette County Sheriff's Department, quote, "Well, I put the book in the house by the computer, and then I walked by my sister's and to see if Bobby was home yet, but he just left." Trial defense counsel failed to fully appreciate the police interview of Brian that would have discredited the state's primary witness, Bobby. It was Bobby and not Mr. Avery who was the last person to see Ms. Hallback. According to Mr. Avery's police procedure and investigation expert, Greg McCrary, Bobby should have been investigated as a potential suspect in the murder of Ms. Hallback because of his preoccupation with viewing violent pornographic images resembling Ms. Hallback, his false statements to the police, and his perjured statements at Mr. Avery's trial. Additionally, defense counsel could have hired a forensic pathologist, as current post-conviction counsel did, who would have offered the opinion that the scratches on Bobby's upper back that were photographed on November 9, 2005 at Aurora Medical Center were inconsistent with his statements to the police that they were caused by his 8-week-old puppy scratching him. Dr. Larry Blum has offered the opinion that the scratches on Bobby's upper back are inconsistent with the dog's paw and consistent. E. Failure to establish Mr. Hilgas as a Denny third-party suspect. Trial defense counsel failed to investigate and gather evidence about Mr. Hilgas. The following pieces of evidence regarding Mr. Hilgas were overlooked by trial defense counsel and demonstrate there was failure to conduct a significant investigation consistent with Mr. Avery's constitutional right to have effective counsel. 1. Concealment by Mr. Hilgas of his abusive relationship with Ms. Hallback. 2. Failure to impeach Mr. Hilgas on his trial testimony that the relationship between Ms. Hallback and Mr. Blodorn was platonic, when in fact it was sexual in nature. 3. Failure to impeach Mr. Hilgas with his untruthful statement to the police about Ms. Hallback's alleged insurance claim for her damaged parking light, when in fact no such insurance claim was made and the parking light was found in the rear cargo area of the RAV4 after Ms. Hallback's disappearance. 4. Failure to obtain an alibi from Mr. Hallback or Mr. Hilgas, or impeach him with the significant gaps in his phone records during the time of the murder. 5. Failure to impeach Mr. Hilgas regarding the 8 minutes and 55 seconds of telephone deletions from Ms. Hallback's phone after he obtained her username and password and accessed her phone. 6. Failure to impeach Mr. Hilgas as to his location when he received 22 unidentified dropped phone calls between 3:11 p.m. and 7:25 p.m. on November 4, 2005, the night trial defense counsel suspected the RAV4 was planted on the Avery property. 7. Failure to impeach Mr. Hilgas with the contradictory statement that the cell phone coverage on the Avery property was absolutely horrid when he had testified that he had never been on the Avery property prior to November 5, 2005. 8. Failure to discover that Mr. Hilgas was in possession of Ms. Hallback's day planner, which was in her vehicle at the time of her murder. F. Trial defense counsel failed to investigate a variety of additional topics. Current post-conviction counsel describes in the motion for post-conviction relief filed June 7, 2017, a variety of failures of trial defense counsel to conduct a significant investigation before trial. 4. The circuit court erred as a matter of law in ruling that it was not authorized by statute to resolve claims of ineffective assistance of prior post-conviction counsel, and that Mr. Avery would have to pursue that claim with the Court of Appeals pursuant to State v. Knight. The circuit court held that, quote, a circuit court is not authorized by statute to resolve claims of ineffective assistance of appellate counsel, State v. Knight. In this matter, if the defendant wishes to pursue the claims regarding appellate counsel, the defense may file a Knight motion with the Court of Appeals, unquote. A standard of review. When, as here, the circuit court's decision turned on a matter of law, the appropriate standard of review is de novo. See Olson versus Town of Cottage Grove. Whether counsel was ineffective as is a mixed question of fact and law. B, Mr. Avery is not challenging ineffective of prior appellate counsel. Contrary to the circuit court's interpretation, Mr. Avery is not challenging the effectiveness of appellate counsel. He claims focus exclusively on the deficient performance of prior post-conviction counsel and failing to raise the ineffectiveness of his trial defense counsel. Mr. Avery does not raise a single issue regarding his appellate brief or oral argument. The Wisconsin courts distinguish claims challenging the effectiveness of post-conviction counsel from those challenging the effectiveness of appellate counsel. Because Mr. Avery's ineffective assistance of counsel claims relate to his prior post-conviction counsel